before his elevation to the Supreme Court in 2019. As NALSA's executive chairperson, he has undertaken and led several innovative initiatives to help those at the margins. And on 24th of November this year, he was sworn in as the Chief Justice of India. Now, it's our privilege to have him this morning. I must also say that this is a time when judiciary has become a point of central debate. Please join me in welcoming Honorable Chief Justice of India, Justice Surya Kant. Just a quick note, we will also have this conversation both in English and in Hindi. So let me begin with your personal journey. From a village in Hisar to CJI's office, what aspects of your early life and legal journey most shaped your approach to justice and leadership? Did you always know you wanted to become a lawyer and later a judge?
Growing up in a village like Petwad taught me a good lesson to be very, very patient, knowing fully well that growth takes its own time. Initially, when you have a background schooling in a village and then you move to a township, from there to the High Court and then eventually in Delhi, it's a long journey, full of struggle. But at the same time, as I said, the lesson which I learned and accordingly I shaped myself was that I need to have a lot of patience. I must wait for my turn and I must invest in myself through hard work and commitment. And that, I would say, eventually paid me.
Sir, having risen from the district courts to the High Court and then the Supreme Court, judicial administration has been a defining strength of your career. From that vantage point, what do you see as the most structural vulnerability of the judiciary right now? And what are the important reforms that judiciary needs?
Utkarsh, I have the advantage of, as I said, I started initially from the district courts. So I had a first-hand interaction with the district judiciary. Then I shifted to High Court. And High Court also, besides, I would say, a successful lawyer in private practice, then I took over as Advocate General of the state. So I had the advantage of seeing the other side of the court proceedings and how you conduct yourself as a professional. I had almost a stint of almost 4 years as Advocate General when in the morning I resigned and I took over as judge at 10 a.m. I had the privilege and the honor and the opportunity of serving under various very eminent Chief Justices who had a lot of trust in me. They gave me a lot of administrative responsibilities, which made me to learn to open vista and to understand the internal functioning of the judiciary. Eventually, when I went as Chief Justice of the High Court, by that time I had a very fair experience of working on the administrative side. Then I got the opportunity to serve as Chief Justice of the High Court for almost 7 months before coming to Supreme Court. Even as a young judge, I would say that I was very fortunate because the then Chief Justice of India, they gave me certain responsibilities even as a young judge. I was in 2007, when I was 3 years old judge, I was taken to the governing body of the National Legal Service Authority at that time, and I was given 2 consecutive terms for 4 years. Then I was picked up for the Indian Law Institute, the deemed university. So all these opportunities gave me an exposure to perform on administrative side and also to understand the nitty-gritties of the judicial system and the challenges we really face on day-to-day basis. So I would say that before I have taken over, there is an experience with me as my asset, and I wish to capitalize that. Knowing the fully background of the system, the institution, the difficulties and the challenges. My first priority will be, I know that institution has multiple challenges like any other constitutional democratic setup has. My first priority will be for the predictable timeline and a unified national judicial policy based early decision of the pending cases. I am not saying the elimination of all the areas. That will never happen, that should not happen. Because the litigation is an ongoing process. People have trust and faith in the judicial system. The cases will be filed. But the old cases which are staring on our face, I really need to tackle that area. And for that, one, I really need to explore the mediation as one of the powerful game changer. And as you know that from last almost 1 year and particularly last 6 months, I have launched that mediation for the nation mission. It is coming up very well. There is a very encouraging response to that. So mediation is one tool that I really wish, along with the cooperation of my sister and brother judges in the Supreme Court and the High Courts, we are going to give really a very expensive platform to mediation for that purpose. The second thing is the prioritization of certain litigations. You will find some reforms I have already made in Supreme Court. Some I am on Monday onwards, again I am doing it. I just want to send a very clear and a strong message that Supreme Court is also meant for the common man. And any ordinary litigant will also have a sufficient space and time in the Supreme Court, and for that I am doing some prioritization of the matters to be listed. Of course, this is one mission which I alone cannot do it. So my sister and my brother judges, they have extended full cooperation in that regard, and I am quite sure with the help of all the domain experts and those who have really come forward with various suggestions, I am going to meet this challenge successfully.
So you have often said that the strength of a judicial system is measured at the district level. So let us talk about a judicial officer who is deciding bail in a very high profile sensitive case but fears criticism from higher courts. What will be your message as the head of the judiciary to such judicial officers?
You want my message to the entire judiciary? Well, the Indian judiciary as such is a very dedicated community. I am absolutely confident about their commitment, about their integrity, about their competence, and about their zeal to deliver justice. What we need to do is that there are various newer challenges with the judicial system faces. There are certain cases, for example, nobody ever thought of that one day you will have the cases like digital arrest. So new challenges will continue to come. First, we need to update our judiciary. For that, periodical trainings in our judicial academies, National Judicial Academy and the state judicial academies. We need to have the training programs regularly. We must update our judicial officers with the newer challenges and how to deal with those cases. Second, the optimum utilization of the human resources we have. I wish to have a fair evaluation of the human resources optimum utilization. For that, some mechanism is being evolved. And we will certainly encourage those who really perform well. There must be a recognition of merit in the institution. Nothing should else factor in the matter of incentivizing the officers in future. A similar pattern, I am quite sure the High Court judges who are constitutional authorities themselves, and I am not going to dictate them anything, but I am absolutely sure and confident that they too will come forward to extend their full cooperation and support in that regard. So as a team, right from the district judiciary up to the Supreme Court, we need to and we will work together to give our best of the performance.
So another significant conversation concerns diversity. Now, India's judiciary is currently talking about debating diversity through gender, caste, profession, lived experience. How do you view this necessity or need for greater inclusions?
Utkarsh, just see, you compare the judiciary of early 2020-25. There is a paradigm change in the Indian judicial system itself, in the way the society has grown, the way the country has moved forward. That reflection must come in judiciary also. In 1950, when formally the Indian Supreme Court was established, the strength at that time and the periodical growth in the increase in the strength of the Supreme Court, and similarly in the High Courts. That increase in strength has given us an opportunity, a platform to bring inclusivity in the Supreme Court. Now you will find that there is a concerted effort by the Supreme Court Collegium or even whatever the system earlier we've been having, to bring the judges from different regions, from different, to ensure the community representation, the regional representation, and to meet with the regional aspirations. And in that process, we have always kept in view that the persons having the background of marginalized communities, the women, they must get adequate and fair representation. And that inclusivity, that diversity has really brought a very rich culture in the Supreme Court. My sister, my brother judges, they belong to different parts of the country. They carry with their own experiences, their best practices in their region. That culture, the conventions, the practices they follow, and everything, the entire a combination of the cultural impact comes in Supreme Court, and we find within the Supreme Court that it represents truly the Indian culture and India as a whole.
So if diversity is one pillar of the institutional strength, judicial independence is certainly the other. So the next question that I have for you is about the judiciary's independence, the perception of it, and the reality of it from the executive. What core principles are necessary to protect both the reality and the perception of judiciary's independence when just one social media post can trigger massive outrage?
You see, when we talk of independence of judiciary, I think we must only keep one basic principle in mind, that is the constitutional philosophy of separation of powers. The judiciary, the legislature, and the executive. The Constitution has so beautifully defined their respective roles, ensuring that there is no overlapping. But at the same time, it is the beauty of our Constitution that a unique compatibility, a unique complementary relationship to each other is what our constitutional philosophy says. Keeping that in mind, we must always also realize, and there is no inhibition in that for so many administrative issues, there is a lot of dependability on each other. If I need financial assistance, I need allocation of a budget. If I need certain other posts to be sanctioned, if I need infrastructure, I have to look towards the executive. If I need certain reforms in certain statutes or where a kind of rule making power question comes, then I have to look toward the legislature. So this interdependability in constitution is also well defined. This is something, a well-oiled machine where if you depend on each other, but at the same time the cogs don't become defunct. It works very well. So it's a machinery where all three organs work together, complementary and supplementary to each other, maintaining their independent identity. And that is what the Indian constitutional culture, constitutional philosophy, constitutional morality demands.
So the need to reduce pendency and delays in the judiciary is something which is very often talked about. You also spoke about mediation. So what I would want to know is about how can we institutionalize mediation and other alternative resolution mechanism in India?
As I said earlier also, mediation is proving to be a very effective tool, and the reason is very obvious. One is the cost effectivity. Mediation as compared to other alternative dispute resolution mechanisms is very, very cost effective. The second landmark in it is that mediation creates win-win situation for both parties. This is one rare tool of adjudication where both parties leave the courtroom or the mediation center with smiling face. It brings social harmony, it keeps intact the social fabric, and it speaks in the common man language. That's the most important thing. All mediators, I have been, if you were there in the first mediation convention and the conference which the learned Attorney General had organized, when I was asked to speak, I said mediation will be successful only when the mediators start speaking the language of the consumer of justice for whom the mediation process they intend to initiate. So when you are talking to them in their own language, when you are talking to them as if they are sitting in an environment which is so friendly that the fear and that aura of court, it does not create any stressful moment for them, it brings lot of successful stories. And as I said, it takes less time, and every stakeholder, every person, different walk of life can work as mediator. So it is not that you require a dedicated class of advocates only. There are retired people who are working as mediator. There are, now that on 8th November, we have launched community mediation also. So I am quite sure that with this, the modicum of mediation, we will be able to reach villages, the streets, and all those houses where either there is a dispute already there or we are apprehending a dispute may arise. So our objective is to reach out there and provide a alternative platform to them.
So at the heart of all these questions is the access to justice. You have worked as the NALSA's executive chairman and it reflected a commitment to those at the margins. What should access to justice mean in the modern 21st century India?
You see, access to justice is a very simple expression. Access to justice is that how swiftly, in terms of very less cost effectivity, with a clear prediction, with dedicated timeline, you can ensure to provide justice to the person who is there before the court. The challenge is, one of the challenges when we talk of access to justice is how to ensure that the person particularly belonging to the vulnerable classes or the marginalized sections of the society, how to ensure that they get a quality legal assistance in court. One. Two, their matters are also prioritized with equal sensitivity as we think of sometimes big cases are being taken. Three, they should also have a sense of satisfaction when they leave the court that we have been treated equally, we have been given full respect in terms of the court environment, the court atmosphere, and the court has been swift impartial, fair in providing them whatever the ultimate verdict comes. Now, when I talk of access to justice, my first priority is to ensure how to reduce the cost of litigation and how to prescribe a reasonable timeline within which the matters are decided. For that, first, cost effectivity. We have expanded the platform of free legal aid. All those marginalized, the vulnerable classes, or those living below poverty line, or those who in any case within the criteria prescribed under the statute, if they qualify for free legal aid, we have launched a massive program throughout the country to provide quality legal assistance. So it is not that the lawyers who don't have work or those who are not treated to be so competent will be only empaneled. We have really moved out far ahead, and all those competent lawyers who really have a name in profession at the local level, even they are also being engaged, and a respectable honorarium is being paid to them to ensure quality legal assistance to the persons who need it. And as far as second part, timeline and predictability is concerned, for that the district judiciary need to be sensitized, and for that, as I said earlier, we intend to launch certain programs through the Judicial Academy platforms or through the High Court platforms to ensure that every member of the Indian judiciary is committed and has some docket management of their own court to ensure that there is a timely justice delivery.
सर, अब हम कुछ सवाल हिंदी में लेना चाहेंगे। आप हरियाणा से आने वाले पहले चीफ जस्टिस हैं और आप देश के 53वें चीफ जस्टिस हैं। तो सुप्रीम कोर्ट हमेशा रीजनल रिप्रेजेंटेशन की बात करते आए हैं, तो ऐसा क्यों है कि 75 साल लग गए सुप्रीम कोर्ट को देश हरियाणा से पहला चीफ जस्टिस पाने में?
नहीं, पहले तो मैं आपको थोड़ा सा इसमें करेक्ट करूंगा। हरियाणा 1966 में बना, तो हरियाणा को 75 साल नहीं लगे, 59 ईयर्स तकरीबन लगे। मुझे इस बात का स्वाभाविक रूप से मुझे गर्व है कि मैं अपने प्रदेश से और अपने क्षेत्र से मैं बंस का। लेकिन मैं ये भी आपको बताना चाहूँगा कि इसी प्रांत से 1966 से पहले जब ये ज्वाइंट पंजाब था या उसके बाद प्रदेश से और विशेषकर मेरे क्षेत्र से बहुत ही अच्छे विद्वान जज हुए हैं, बड़े अच्छे विद्वान अधिवक्ता वकील भी वहाँ से हुए हैं, और बहुत ही अच्छे जिसको आप जो एकेडमिक साइड में रहे ऐसे प्रोफेसर्स वगैरह भी लॉ के बहुत ही अच्छे अच्छे उस क्षेत्र से हुए हैं। तो जुडिशियल सिस्टम में, उसमें जुडिशियल एजुकेशन से लेकर के जुडिशियल सिस्टम के जज में या बार और बेंच दोनों में बहुत ही अच्छे लोग हुए हैं, उन्होंने बहुत अच्छा काम किया, और उन सब का जो भूमिका रही है वो मेरे लिए एक बहुत बड़ा मार्गदर्शन रहा है पहुंचने में। और मुझे ऐसे लगता है कि मैं शायद उन्हीं के दिखाए रास्ते पर, उन्हीं के मार्गदर्शन से और उन्हीं के आशीर्वाद से मैं यहाँ तक पहुँचा हूँ।
सर, जब सब कुछ इतनी तेज़ी से बदल रहा है, कानून भी, समाज भी, न्याय भी, तो आपको क्या लगता है कि न्यायाधीशों और न्यायालय को सीखते रहने की कितनी ज़रूरत है?
देखिए, आपका मेन प्रश्न बताइए क्या है?
सर, सवाल ये है कि कानून भी बदल रहे हैं, समाज भी बदल रहा है, विचारधाराएं बदल रही हैं, साथ में तकनीक भी बदल रही है। तो ये जुडिशियल लर्निंग फॉर दी कोर्ट्स एंड दी जजेस, हाउ इम्पोर्टेंट इज दैट? वो कितना ज़रूरी है?
नहीं, देखिए, अगर बदलते समाज की बारे में अगर कोर्ट अगर उनको ज्ञान नहीं होगा या अपने आप को वो बदलती हुई स्थितियों को, परिस्थितियों को नहीं समझेंगे, तो मुझे लगता है कि कहीं ना कहीं जस्टिस डिलीवरी सिस्टम में एक डिफ़िकल्टी आएगी। कोर्ट्स के लिए इतना इम्पोर्टेंट है अपने आप को अवगत करना और समाज के जितने भी बदलते परिवेश के बारे में, देश की जो भूमिका बदलती है उसके बारे में, आपके आसपास की भूमिका, उस सबको आपको जानना बहुत ज़रूरी है। मैं इस कंसेप्ट को नहीं बिलीव करता ये बदलते हुए समाज उसकी वजह से बोलता हूँ कि पहले एक बोला जाता था कि जजेस विल रिमेन सिक्लूडेड, दुनिया से सबसे आइसोलेट रहेंगे। आइसोलेट रहिए, आपको जरूर आवश्यकता नहीं है कि आप हर पब्लिक फंक्शन में, हर क्लब में, हर किसी भी उसमें आप जाएंगे, ऐसा कोई ज़रूरी नहीं है। आप अपने आप को रखिए उसको, लेकिन इसका मतलब ये नहीं कि आप दुनियादारी को भूल करके आपके आसपास समाज कैसे बढ़ रहा है, देश कैसे बढ़ रहा है, और देश के आगे आसपास के देश कैसे बढ़ रहे हैं, कैसे व्यवहार कर रहे हैं, आप उन चीज़ों के बारे में बिल्कुल नहीं रखें। जुडिशरी का अपने आप को अपडेट करना बहुत इम्पोर्टेंट है, और जब आप अपने आप को अपडेट करते हैं तो आपके सामने, तभी आप जो नए नए चैलेंज आपके सामने आ रहे हैं, तभी आप उनको समझ पाएंगे। मैं आपको उसी एक उदाहरण को दोबारा रिपीट कर रहा हूँ। डिजिटल अरेस्ट है, अब डिजिटल अरेस्ट को भी छोड़ दी, किसी भी प्रकार का साइबर क्राइम है, साइबर क्राइम जरूर ये तो नहीं है, आपका विक्टिम तो इंडिया में हो सकता है, विक्टिम आपके गांव में भी हो सकता है, विक्टिम आपकी कोर्ट के ज्यूरिसडिक्शन में हो सकता है, लेकिन जो क्रिमिनल है वो पता नहीं किस आइलैंड पे बैठ करके कर रहा है। तो जब तक आप इस प्रकार के ऑफेंस कैसे, क्राइम कैसे कमिट होता है, इसकी प्रक्रिया को नहीं समझ लेंगे, आई डोंट थिंक दैट यू विल बी एबल टू डिलीवर जस्टिस। इसलिए जुडिशरी को अपने आप को अब्रेस्ट करना हर चीज़ में बहुत इंपॉर्टेंट है।
Sir, we'll conclude this conversation with a question that speaks to the theme of this year's summit. When you look ahead to transforming tomorrow, the theme of this year's summit, what gives you optimism about India's legal and democratic future?
Well, I am a very optimistic person, and I am absolutely confident that the Indian democracy and the Indian justice delivery system both have a very bright future. The reason is very obvious. First, Indian people have absolute commitment to the constitutional principles. Second, Indian people have their commitment to the rule of law. Three, Indian people have commitment to the democracy. Once there is a commitment for the rule of law, once you believe in democratic values, and once you follow the constitution philosophy, the judiciary has a very vital role in all these three components, and therefore the judiciary is also bound to rise. And why I am very optimistic about Indian judiciary is when I see the youth of this nation, the wealth of knowledge they possess, their informed knowledge about what is happening in different parts of the globe, their quickness in response, their brightness in developing innovative judicial jurisprudence. I think I am absolutely confident, and their capacity to face different kind of challenges that ensure that Indian judiciary in future is in very safe hands.
Thank you, Justice Surya Kant. Thank you for your time, your candor, and your vision. On behalf of Hindustan Times, we wish you a very meaningful and inspiring tenure. Ladies and gentlemen, please join me in giving him a warm round of applause.
Thank you.
Thank you very much, Honorable